Dad left you nothing, Claire. He told me himself. You didn't deserve it. Those were the first words my brother said to me in the lawyer's conference room, before I'd even sat down. Not hello, not I'm sorry for your loss. Just that. He said it flat, like he was reading me a weather report, while the family attorney shuffled papers and wouldn't meet my eyes. I want you to sit with that sentence for a second, because I did. I sat with it for months, and I want to tell you exactly what happened after, because my brother believed our father's last word on the matter had been spoken. He was wrong. Our father had one more thing to say. He just hadn't said it to Trent. He'd said it to a stranger, in a small office 40 minutes away, 2 months before he died. And when that came out, it wasn't a shouting match that proved it. It wasn't tears in a courtroom. It was a signature. My brother's own signature, sitting quietly in a filing cabinet, waiting to contradict him. My name is Claire Bennett. I'm 44 years old, a hospice nurse, married to a good, steady man named Mark, mother of 2 teenagers who roll their eyes at me with real affection. I tell you all of that so you understand what kind of person I was walking into that conference room. Not a woman looking for a fight. Not someone who'd spent her life scheming for money. Someone who spent her career sitting with dying people and their families, watching what money does to people when grief cracks them open. I thought I understood it. I didn't understand it would happen to me. Walter Bennett, my father, was a machinist for 31 years at the same plant before it closed, and he limped into an early retirement he never quite recovered from, financially or otherwise. He was not a rich man. He was a careful one. The house he and my mother bought in 1987 for $68,000 was worth, by the time he died, close to $220,000, paid off, not a cent owed on it, because my father treated debt like a personal insult. Add in his savings, a small pension buyout he'd invested conservatively, a life insurance policy he never touched. When it was all totaled, the estate came to just over $340,000. Not a fortune, but it was everything he had. It was 31 years of a man getting up at 5 a.m. so 2 kids could have Christmas and college and a roof that didn't leak. We lost my mother when I was 26. Trent was 23. After that, my father lived alone in that house for almost 2 decades. And the truth is, our family split along a fault line that a lot of families know well. I moved away. Trent didn't. Here's the honest part, because it matters later. I moved 3 states over for nursing school, then stayed for the job, then stayed for Mark, then stayed because that's just what happens. Life roots you somewhere and the roots hold. I called my father every Sunday without fail. I flew back 4, sometimes 5 times a year. When his knees got bad, I was the one who researched the surgeons and flew out for the operation and slept in a recliner in his hospital room for 4 nights. When his bank tried to close his account over some fraud flag, I was the one on the phone with customer service for 2 hours from 600 miles away because Trent said he was too busy with work. Trent stayed in town. He moved back in with Dad when he was 31, after his second marriage fell apart. And it was supposed to be temporary. It was supposed to be 6 months. It became 11 years. For a long time, I was grateful for that. I'll admit it plainly, because it's the truth, and it's part of why what happened later cut so deep. I thought Trent staying close was a gift to our father, and by extension, to me. I thought, someone's there. Someone can grab the mail, drive him to appointments, notice if something's wrong. I sent money sometimes, for groceries, for the utility bills when Trent was between jobs, which was often. I never once resented it. He was there and I wasn't, and in my mind, that bought him nothing but my thanks. What I didn't see, because I was 600 miles away, because I trusted my own brother, because you don't audit your family, was that being there had quietly become being in control. Somewhere around the time our father turned 78, 3 years before he died, Trent became his power of attorney. I remember that phone call. Dad told me about it almost as an afterthought, at the end of a Sunday call, the way you'd mention you'd finally gotten around to cleaning the gutters. Trent's going to help me with the bills and things, he said, since he's right here. I said that sounded sensible. I meant it. My father's hands had started to shake. His memory, in small moments, had started to slip, misplacing his glasses, repeating a story twice in one conversation. The kind of thing that could be nothing, or could be the first quiet knock of something worse. It was, eventually, something worse. Not dementia exactly, the doctors were careful about that word, but a slow, vascular decline that stole pieces of his sharpness the way water erodes a riverbank. So gradually, you only notice the damage when you step back and look at how far the water's moved. And somewhere in that slow erosion, a will was written. I didn't know about it. Let me say that clearly, because it will matter enormously in about 20 minutes of this story. I did not know a will existed that named Trent as the sole beneficiary of everything our father owned. The house, the savings, all $340,000 of it. Until the day I sat in that conference room and heard my brother say I didn't deserve any of it. The will was dated 3 years before my father's death. It stated, in language that still makes my stomach turn when I think about it, that Walter Bennett was leaving his entire estate to his son Trent, in recognition of his son's constant care and companionship, and due to the long-term estrangement of his daughter Claire. Estrangement. I had called that man every single Sunday for 18 years. I had a phone bill that would prove it before I ever needed a lawyer to. There's more you should know about who my father actually was, because it matters for understanding just how wrong that word felt sitting on the page. Walter Bennett was not a warm, effusive man. He didn't say, "I love you" easily. That generation of men rarely did, but he showed it in ways you had to know him to read. He wrote the date of every one of my nursing school exams on his kitchen calendar and crossed them off when I called to tell him how they'd gone. He kept a coffee can on top of his refrigerator for 30 years that he called Claire's Rainy Day Fund, and every few months he'd drop a 20 in it, even after I was grown and married and didn't need it, because it made him feel like he was still taking care of me from a distance. I found that can, still half full, when I cleared out his kitchen after the funeral. Trent didn't know it existed. That's the man the will claimed had decided I didn't deserve anything. That's the man Trent stood in front of a lawyer's desk and told me, without flinching, had said those words about me himself. Grief does something strange to time. In the 2 weeks between my father's death and the will reading, I don't think I fully processed either. I flew back for the funeral, stood next to my brother at the graveside, hugged him, cried with him, genuinely, because whatever had happened, whatever I would later learn, in that moment, he was still my little brother, and we had just buried our father, and none of the rest of it had surfaced yet. It surfaced 11 days later, in a law office that smelled like old carpet and burnt coffee, across a table from a family attorney named Gerald Whitfield, who had drafted wills for half the older families in that county, and looked, frankly, uncomfortable the entire meeting. Trent's line, "Dad left you nothing, Claire. He told me himself, you didn't deserve it," landed on me like a physical blow. I remember gripping the edge of the table. I remember Mr. Whitfield saying my name, gently, trying to walk me through the document, and I remember not hearing most of it because my ears were ringing. Estrangement, constant care and companionship, sole beneficiary. I asked to see the will. I read the language twice, 3 times. I looked at the signature at the bottom, my father's name, in his handwriting, or what I registered in that moment as his handwriting. Because grief does not make you a document examiner. It makes you a person trying not to fall out of a chair. "When did he sign this?" I asked. Mr. Whitfield checked the date. 3 years earlier. Right around the time Trent became his power of attorney. I looked at my brother. Understand this, I did not scream. I did not accuse him in that room. 20 years of nursing has taught me that the moment you raise your voice, people stop listening to you and start defending themselves. And I needed, more than anything in that moment, for someone to keep listening. So I asked, quietly, "Trent, why would Dad say I was estranged? I talked to him every week." And my brother? My brother looked me dead in the eye and said, "You weren't here, Claire. You weren't here for any of it. I was the one who was here." That sentence was true. And it was also, I would come to understand, a sleight of hand, because you weren't here, and he cut you out because he believed you'd abandoned him, are two very different claims, and only one of them was something our father would have actually believed. I knew my father. Whatever his flaws, and he had them, he could be stubborn. He could go quiet for weeks when he was hurt about something. He was not a man who forgot who called him every Sunday for 18 years. He balanced his checkbook to the penny into his 70s. He was not, in his right mind, a man who would write the word estrangement about a daughter who flew home 5 times a year. I didn't fight the will that day. I didn't have grounds yet, not real ones, just a feeling, and feelings don't hold up in probate court. I went home to Mark that week, and I told him what happened, and he did something that turned out to matter more than either of us knew. He said, "Claire, if something's wrong, it won't look wrong on the surface. You're going to have to actually look." So I started looking. I began with the phone records. I pulled 18 years of billing history from my carrier. Every single Sunday call to my father's landline, and, later, his cell, logged and time-stamped. It took me 2 days on hold and one very patient customer service representative named Denise, but I got them. 18 years, largely unbroken except for a handful of Sundays when I was traveling for work and had called him Monday instead. That wasn't estrangement. That was a woman who had missed maybe a dozen weekly calls out of nearly 1,000. Then I started thinking back, really thinking back, over the last 2 years of my father's life, looking for anything that had felt slightly off at the time, but that I'd waved away because grief hadn't yet taught me to take it seriously. And there were things, small things at first. About 18 months before he died, my father had called me on a Tuesday, not our usual day, and his voice had a strange, tight quality to it. "Claire," he'd said, "I need to ask you something, and I don't want you to make a big deal out of it." I'd said okay. He'd asked, almost sheepishly, whether I thought he was still sharp enough to handle his own affairs. I told him of course he was, and asked why he was asking. He'd gone quiet for a second and said, "No reason, just wanted to hear you say it." I let it go. I had a shift in 4 hours. I told him I loved him and I'd call Sunday like always, and I hung up. And I did not think about that phone call again for a 1.5 years. Then, about 8 months before he died, there was a call where he mentioned, almost in passing, that Trent had been going through some of my old paperwork, cleaning things up. I'd said that sounded helpful. He'd said, in a tone I now recognize, looking back with everything I know, as something closer to unease than agreement. And then, 4 months before he died, the call that I now think about more than almost any other conversation in my life. He said out of nowhere, near the end of our Sunday call, "Claire, I've been thinking I need to fix something. Make sure it's right. I've been talking to someone about it." "Fix what, Dad?" "Just something," he said. "Don't worry about it. I'll handle it." I asked if he needed help. He said no, he had it handled, and then he changed the subject to my son's basketball season, and I let him change it because he was 81 years old and entitled to his privacy, and because I had absolutely no reason, in that moment, to think fix something meant anything more urgent than a leaky faucet or an overdue tax form. 4 months before that call, though I didn't know it yet, my father had withdrawn $600 in cash from an account Trent didn't monitor as closely as the others, a small old savings account from before the power of attorney, one he'd apparently kept private on purpose. Nor did I know he had taken a taxi, at 81 years old, because Trent had borrowed his car keys that week for a maintenance appointment that, as I'd later learn, never actually happened, to an office in the next town over, to see a lawyer neither of us had ever heard of. I found the taxi receipt, 11 months after he died, folded into the back pages of an old address book I almost threw away. If I had thrown that book away, if I hadn't sat on my father's bedroom floor at 11 at night, going through boxes Trent had grudgingly let me look through but don't take anything, I don't know that any of the rest of this would have happened. I think about that more than I'd like to admit, but I'm getting ahead of the story. Let me go back to the weeks right after the will reading, because the receipt didn't come until later, and before I found it, I had to survive the part where my own brother turned into someone I didn't fully recognize. I asked Trent, calmly, for access to Dad's financial records from the last 2 years, bank statements, the power of attorney paperwork, anything that would help me understand the decisions that had been made. He refused, not angrily, at first. He told me it was handled, that the estate was moving forward, that I was making this harder than it needed to be. When I pushed, gently, he got sharper. "You don't get to swoop in now," he said, "after everything, and start asking for paperwork like you're running an audit." This next part matters, I think, for anyone listening who's been in a version of this situation. The instinct, when your own sibling stonewalls you like that, is to escalate, to raise your voice, to threaten, to make it a battle of who can be angrier. I understand that instinct. I felt it, sharp and hot, more than once. But I had learned something from years of sitting in family meetings at the end of a patient's life, watching adult children fight over furniture while their mother was still breathing in the next room. The people who win those situations, the people who actually get the truth, are almost never the loudest ones in the room. They're the ones who go quiet and go get proof. So instead of arguing with Trent, I called a lawyer of my own. Her name was Diane Osei, a probate and estate litigation attorney 2 towns over from where I lived, recommended by a colleague who'd gone through something similar with her own family. Diane was calm in a way I found almost startling after weeks of tension with Trent, unhurried, precise, the kind of person who asks 3 quiet questions instead of 1 loud one. "Tell me everything you remember," she said in our first meeting, "even things that seem small, especially things that seem small." I told her about the Sunday calls. I told her about, "I need to fix something." I told her about Trent's power of attorney and the estrangement language in the will, and the fact that my father had balanced his checkbook to the penny for 50 years and would never, in his right mind, have described me as absent. Diane didn't promise me anything that first meeting, which I respected. What she did was start pulling threads. She filed a request for the full financial records tied to the power of attorney. Records Trent, as an agent under that document, was legally required to be able to produce, whether or not he wanted to. She subpoenaed 3 years of bank statements from every account my father held. And she asked me to talk to the people who had actually seen my father in his day-to-day life during those final 2 years. Not through Trent's account of things, but directly. That's how I ended up, one gray Thursday afternoon, sitting on the porch of Mrs. Alvarez, my father's next-door neighbor of nearly 30 years. She'd brought him casseroles when my mother died. She'd waved to him from her garden every single morning for 3 decades. She was 81 years old, sharp as a tack, and she had opinions. "Your brother," she said, stirring sugar into her iced tea with more force than the task required, "started acting different with your father the last couple years. Used to be your dad would sit out on that porch every evening, wave at me, chat if I came by. Last year or so, he was inside more. I asked your brother about it once, said I hadn't seen Walter in a while, and he told me your dad wasn't feeling social these days. But then I'd see your dad's light on late, and one time, this was maybe 5-6 months before he passed, I saw him get into a cab, right out front. I remember because it struck me odd, your dad taking a cab, when he had that car sitting right there in the driveway. I felt something go cold and still in my chest. Did he say where he was going? I didn't ask, wasn't my business. But I waved and he waved back, and he had this look on his face, determined almost, like a man with somewhere to be. I told Diane about the cab that same evening. She fell silent on the phone for a moment, and then she said the sentence that changed the entire shape of this story. "Claire, if your father took a cab somewhere he didn't want your brother to know about, 4 to 6 months before he died, I want to know where he went. People his age don't sneak off to surprise parties." Mrs. Alvarez wasn't the only person I spoke to that week. I also drove out to see Walt Regal, my father's oldest friend, a man he'd worked alongside at the plant for nearly 25 years before it closed, and they'd both scattered into different kinds of retirement. Walt was 79, sturdy despite a bad hip, and he still played cards with my father every other Thursday until the last few months of his life, when, he told me, the visits had quietly tapered off. Trent started sitting in on our card games, Walt said, settling into a lawn chair on his back patio, squinting at the afternoon sun. Not playing, just sitting there, kind of hovering. Your dad didn't say much about it, but I could tell it changed things. Men don't talk the same way with an audience, you understand. There were things your dad used to say to me, about being tired, about feeling like he wasn't in charge of his own house anymore, that just stopped coming up once Trent started sitting in. Did he ever say anything specific? About the will or about feeling taken advantage of? Walt was quiet for a moment, turning his glass of lemonade in his hand. Once, he said finally. Maybe 7, 8 months before he passed. We were alone. Trent had gone to get gas or something. Your dad said, out of nowhere, Walt, if something ever happens and it looks like I did something strange with my affairs, I want you to know I always meant for it to be fair. Fair to both my kids. I didn't think much of it at the time. Old men say strange things sometimes, thinking about the end, but I've thought about it a lot since you called me. I sat with that for a long moment. It wasn't proof, not the kind Diane could put in front of a judge, but it was another thread, another small, unprompted echo of the same thing. A man trying, quietly, in whatever moments he could find away from his son's watchful presence, to make sure someone knew the truth in case he ran out of time to fix it properly himself. It took Diane 3 weeks to find him, not through any dramatic detective work, but through the kind of patient, unglamorous process that actually solves things in real life. She pulled a list of every estate attorney within a 20-mile radius of my father's house who wasn't Gerald Whitfield, and she called each office, asking, carefully and within the bounds of what the law allowed her to ask, whether anyone had a file for a Walter Bennett. One conversation from those 3 weeks has stayed with me more than almost anything else in this whole story. The moment I understood, fully, that I wasn't imagining any of it. I called Trent on a Wednesday evening, not planning to accuse him of anything, just hoping, honestly, that if I asked him gently enough, he might tell me the truth on his own, and we could avoid all of what came after. I asked him directly, Trent, did Dad ever talk to you about wanting to make changes to his will? Near the end, there was a pause on the line, just a half-second too long. No, he said. Why would he? No reason, I said. Just wondering if he ever mentioned anything about seeing another lawyer. The pause that time was longer. Where's this coming from, Claire? I'm just asking. You're not just asking. You've got that lawyer of yours going through Dad's bank records like we're criminals. I told you, it's handled. Why can't you just let him rest? I am letting him rest, I said. I'm trying to make sure what's happening honors what he actually wanted. What he wanted, Trent said, and his voice had an edge in it I'd rarely heard from him, not even his kids. Was for the person who was actually here to be taken care of. That's what he wanted. I don't know why that's so hard for you to accept. I didn't answer right away. Into that silence, my brother said something I've turned over in my mind 100 times since. It doesn't matter what you find, Claire. What's done is done. The call ended not long after that. I remember standing in my kitchen with the phone still in my hand afterward, thinking, an innocent man doesn't say, it doesn't matter what you find. An innocent man says, there's nothing to find. I called Diane the next morning and told her about the conversation, word for word, while it was still fresh. She wrote it down. It would later become part of the record too, not as proof of forgery on its own, but as one more thread in a rope that was slowly, steadily, becoming strong enough to hold weight. Around that same time, Diane's subpoenaed bank records started producing their own subtle contradictions. Buried in 3 years of statements from the account Trent managed as power of attorney was a cash withdrawal of $600, made 8 months before my father died, from an older, smaller savings account that predated the power of attorney arrangement entirely. One my father had apparently kept separate and largely untouched for years. The kind of account an elderly man might keep to himself on purpose. A little independence tucked away where a well-meaning son wouldn't think to look. There was no corresponding withdrawal slip filed with Trent's power of attorney paperwork, because legally, he didn't need to account for an account he didn't control. My father had gone to that bank alone. Diane also found, in the notes from Gerald Whitfield's own office file, the attorney who'd handled the first will, something that struck her as odd enough to flag. The intake notes for that original will, 3 years back, indicated the initial draft and instructions had been submitted by phone and by a follow-up visit that included Trent assisting his father with the paperwork. Whitfield's notes described Walter as quiet and letting his son do most of the talking during that meeting. It wasn't proof of anything by itself, but it was a pattern starting to take shape. A son present at every stage of a will that favored him, and conspicuously absent, deliberately kept in the dark, when his father tried to undo it. On the 9th call, a paralegal at a small 2-attorney office in the next town over went still in a way that told Diane everything before a word was said. Diane asked to speak to the attorney directly. His name was Roland Halloway, and 40 minutes later, Diane called me, and I could hear in her voice that she was trying very hard to stay professional and not quite succeeding. "Claire," she said, "your father hired Mr. Halloway. 2 months before he passed, he drafted a new will." I sat down on my kitchen floor. I don't remember deciding to sit down. I just remember the linoleum against my legs and Diane's voice continuing, steady, while the rest of the room seemed to tilt. "Mr. Halloway," once Diane explained the situation and the probate proceeding underway, was willing to speak with us, carefully, respecting attorney-client privilege where it still applied. But a will, once its existence becomes relevant to an estate contest, is a different matter than ordinary confidential counsel, and he'd already begun the process of preparing to come forward as a witness. I sat in his office 2 days later, across from a soft-spoken man in his 60s with reading glasses pushed up into gray hair, and he told me what my father had said to him. "He came in on his own," Mr. Halloway said. "Took a cab, if I remember what he told me. Said his son had the car that week. He was nervous. Not confused, I want to be clear about that, because I did what I always do with an elderly client making a significant change, which is assess capacity carefully before I'll touch a will. Your father was sharp. He answered every question precisely. He knew the extent of his assets almost to the dollar. He knew exactly what he wanted to do and why." "What did he say?" I asked. My voice didn't sound like my own. Mr. Halloway pulled a thin folder toward him. He told me he had a prior will, one his son had drawn up through another attorney, that he'd signed a few years earlier during what he described as a difficult time. He said his son had been very insistent about it, brought the paperwork to him already prepared, told him it was just a standard update, and he'd signed it without reading it as closely as he should have, because he trusted his son, and his eyes weren't what they used to be for reading fine print. He told me that over the following years, he started noticing his son referring to the house and the money in ways that made him uneasy, talking about it like it was already his. And your father started to suspect that whatever he'd signed wasn't the modest update he'd been told it was. I could barely breathe. And the estrangement language? About me? Mr. Halloway's face changed, softened. He was very upset when I read that language back to him from the old will's file summary. I'd requested a copy from the previous attorney's office as part of drafting the update, standard practice. He said, and I wrote this down almost verbatim because it struck me at the time, "I never said that. I would never say that about my daughter. She calls me every Sunday." I put my hand over my mouth. 20 years of professional composure, and I sat in that stranger's office and cried like I hadn't since the funeral. "He wanted it fixed," Mr. Halloway continued, gently. "He was firm about it. He instructed me to draft a new will, properly executed, witnessed by my paralegal and my office manager, both independent, both unrelated to your family, notarized, the whole document reviewed with him clause by clause. This new will explicitly revoked all prior wills. It restored an even division of the estate between you and your brother, and it included a personal statement, in his own words, which I helped him formalize, explaining why he was making the change. He wanted that statement included specifically so that, in his words, there's no confusion about what I actually wanted. Sitting beside me, Diane asked the question I hadn't been able to form. Do you have that statement? Can we see it? Mr. Halloway opened the folder and slid a single page across the desk. I have read that page more times than I can count since that day. I'm not going to recite it word for word here, because some things belong to a family and not to a script. But the heart of it, the part that mattered, said this, that he loved both his children, that he believed his daughter had been present and faithful in every way that counted, despite the distance, and that any suggestion otherwise had never come from his true wishes, that he was concerned his son may have taken advantage of his trust during a period when his health made him more vulnerable than he wanted to admit, and that this new will, and only this new will, represented what he actually wanted done with what he'd spent his life building. It was dated 2 months before his death, properly witnessed, properly notarized, legally, on its face, airtight. But Diane, being thorough, being the kind of lawyer who doesn't let a good find make her careless, didn't stop there. Because a newer will revoking an older one is powerful, but she wanted to understand exactly what had happened with that first will, the one Trent had presented, the one with the estrangement language. If Trent had genuinely believed that document was valid, that was one story. If he'd known, at the time he presented it to Gerald Whitfield's office, that a newer will existed and simply hidden it, that was a different story entirely, one with much sharper legal teeth. So Diane requested something almost administrative, almost boring, compared to everything else. A full set of the documents filed with the probate court as part of the estate proceeding, including the original petition Trent had submitted as executor, which required his own signature, notarized, in multiple places. And this is the part of the story I think about the most, because it's the part that proves something I've come to believe deeply. The truth doesn't usually announce itself with drama. It usually just sits quietly in a filing cabinet, waiting for someone patient enough to go looking. Diane brought in a forensic document examiner named Priya Chandrasekaran, a woman who has spent 25 years comparing signatures and handwriting for exactly this kind of dispute. Priya's job was straightforward on paper and painstaking in practice. Compare the signature on the original, 3 years earlier will, the one naming Trent's sole beneficiary, against a set of verified, authentic exemplars of my father's actual signature, pulled from tax documents, medical consent forms, and his driver's license renewal, all independently sourced and dated close to when that first will was supposedly signed. It took Priya 11 days. Her report ran to 14 pages, most of it dense with terminology about stroke pressure and letter formation and pen lift patterns that I only half understood. But the conclusion was written in language even I couldn't misread. The signature on the 3-year-old will showed characteristics inconsistent with my father's genuine signature during that period. Subtle but measurable differences in the formation of the capital W, in the spacing, in a small looping flourish my father had made on the final T in Bennett, his entire adult life, present in every verified exemplar and conspicuously altered on the disputed document. And then Priya did the thing that gave this story its ending. The reason my brother's own signature is the one that undid him. As part of a thorough comparison, standard in contested will forensics, she requested known handwriting samples from every person who might plausibly have had access to draft or alter the document. That included Trent, not as an accusation yet, simply as due diligence, using signatures he himself had provided on court filings and notarized power of attorney paperwork, documents he had signed dozens of times over 3 years without ever imagining they'd be used this way. What Priya found was this: certain distinctive formations in the disputed will's signature, the pressure pattern in the downstroke of the W, a specific, slightly unusual way the letter B curved before straightening, didn't match my father's genuine hand at all. They matched Trent's, not identically, Whoever had produced that signature had clearly tried to imitate my father's handwriting, and in places, done it well enough to fool a grieving family in a lawyer's office. But under close forensic comparison, the attempt carried, unmistakably, the underlying muscle memory of the person who'd actually held the pen, and that muscle memory belonged to my brother. He had, at some point during that difficult stretch, probably not long after becoming power of attorney, probably while our father's judgment and eyesight were at their most vulnerable, prepared a will favoring himself, and either had our father sign something he didn't fully understand, or, in at least one contested signature location Priya flagged with the highest confidence, signed it himself. His own hand had written the lie, and his own hand, 3 years later, on entirely unrelated court paperwork he'd had no reason to think mattered, had handed Diane and Priya the very thing they needed to prove it. I asked Priya, when she walked me through her findings, how confident she really was, because 14 pages of technical language can sound authoritative without necessarily being certain, and I needed to know the difference before I let myself believe it. She was careful with her answer, the way good experts always are. In forensic document examination, she told me, we rarely deal in absolute certainty, but this case gave me an unusually strong basis for comparison. A large set of verified authentic exemplars from your father, spanning decades, and a large set of verified exemplars from your brother, spanning years. The disputed signature doesn't just fail to match your father's hand, it positively matches specific, unusual formations in your brother's hand, formations that are, statistically, very unlikely to occur by coincidence between two unrelated writers. I testified in my report that the evidence supports authorship by Trent Bennett to a high degree of confidence, not merely that your father's authorship is doubtful. That distinction mattered enormously once we were in front of a judge. It's one thing to say a signature looks a little off. It's another to say, with data behind you, that the pen was almost certainly held by someone else's hand, and that hand belonged to the very person now holding out that signature as truth. I asked Mr. Halloway, before we left his office that first day, one more question, the one that had been sitting under my ribs since he'd started talking. Did my father seem scared? When he came to you? He considered it for a moment, the way a careful man does before answering a question he takes seriously. Not scared exactly, he said. Resolved. I've drafted a lot of wills for a lot of people at the end of their lives, and there's a particular look people get when they're settling something out of fear or spite. Your father didn't have that look. He had the look of a man doing a chore he should have done sooner, and was relieved, finally, to be doing right. He told me, right before he left that day, I should have come here myself the first time, instead of trusting someone else to bring me the papers. I didn't fully understand what he meant by that until your attorney called me about the contest. If you've stayed with me this far, you've probably noticed something. None of this came from shouting. It came from patience, from a stranger who did his job carefully, and a father who was stubborn enough to make one more quiet trip while he still could. If a story like that means something to you, if you believe the truth is worth waiting for, even when it takes months, even when the people closest to you are the ones standing in its way, stay subscribed, because there are more stories like this one still to tell. Next time, a woman spends 4 decades believing she was the family disappointment, until a locked drawer in her mother's house tells her exactly why she was really sent away. The probate hearing was nothing like the will reading. It was quiet, procedural, almost anticlimactic in the way that real justice so often is. No raised voices, no dramatic gasps in a gallery, just a judge in a modest county courtroom reviewing exhibits, Mr. Halloway's testimony and file, notarized and independently witnessed, Priya Chandrasekaran's forensic report, methodical and unshaken under cross-examination, the taxi receipt, the phone records, Mrs. Alvarez's sworn statement about a cab pulling up to a house where a car sat unused in the driveway. Trent's attorney tried to argue that the discrepancies in the original signature could be explained by our father's declining motor control, that an 81-year-old man's handwriting naturally drifts. It was a reasonable argument on its face, and for about 4 minutes I watched it work its way into the judge's expression, saw her considering it seriously, the way a fair judge should. Then Priya was recalled, briefly, and explained patiently, without a trace of drama, that motor decline changes a signature's consistency and pressure control, but it does not change a person's fundamental letter formation into someone else's fundamental letter formation. A shaking hand still writes its own W. It doesn't start writing someone else's. The judge admitted the second will, the one drafted by Mr. Halloway, signed 2 months before my father's death, independently witnessed and notarized, as the valid controlling document. She found, based on the forensic evidence, sufficient grounds to invalidate the earlier will entirely, not merely as superseded, but as improperly executed. She noted, in her ruling, that the matter of the disputed signature's authorship might warrant referral to the district attorney's office for further review, a door that remains, as of the writing of this account, still open, though it isn't one I've chosen to push through myself. I watched Trent's face while the ruling was read. I'd braced myself for anger, for some outburst that would confirm everything I now believed about him. It didn't come. What came instead was smaller and, in its own way, harder to watch. His shoulders dropping, his eyes fixed on the table in front of him, the particular stillness of a person who has just run out of stories to tell himself. His attorney leaned over and said something quiet to him. He didn't respond. When the hearing ended, he left through a side door without looking at me, and I let him go. I didn't chase him into the hallway. There was nothing left to say that a courtroom hadn't already said better than either of us could. Outside, on the courthouse steps, Diane put a hand on my shoulder and said simply, "Your father made sure of this. All you had to do was find it." I've thought about that sentence often since. All I had to do was find it, as if that were a small thing, as if it hadn't taken months of phone records and taxi receipts and an 81-year-old neighbor's memory and a forensic examiner comparing pen strokes under magnification. But she was right, in the way that matters most. My father did the hard part. He got himself into that cab. He sat across from a stranger and insisted the record be corrected, at an age and in a condition where most people would have simply let things lie. All I had to do was be stubborn enough, afterward, to go looking for what he'd already left behind. Here's the part I'll be honest about, because it matters. People often expect these stories to end with the villain frog marched away in handcuffs, and I understand the appeal of that ending. It's clean. It's satisfying in a way that real life rarely bothers to be. But my brother is still my brother. Whatever he did, and the evidence is not kind to him, I won't pretend otherwise. He is also the man who sat beside our father through the last, hardest years of his life, in a way I, 600 miles away, was not physically able to do. I have not pursued criminal charges. Diane tells me the state may still choose to, independent of anything I do. And if that happens, that will be its own reckoning, separate from mine. What I did do was accept what the court affirmed, that our father's true wishes, expressed clearly, competently, and on his own initiative in a small office 2 months before he died, were that his estate be split evenly between his 2 children, half of $340,000, a little over $170,000 after fees and costs were settled. I used some of it for what you'd expect: a dent in my son's college fund, a long overdue roof repair, an emergency fund that let me breathe a little easier for the first time in years. But I set aside a piece of it too, in an account with a small plaque of a name on it that only Mark and I know exists. Walter's Fund, for exactly the kind of thing my father would have quietly wanted. Help for families going through the very thing our family went through: elder financial abuse and the isolating confusion that comes with it, given anonymously through the hospice organization I've worked with for 2 decades. Trent and I haven't spoken since the ruling. I don't know if that will change. Grief, I've learned. Real grief, the kind that outlasts a funeral by years, doesn't resolve as neatly as court paperwork does. There's no forensic examiner for what happened between a brother and a sister. There's just time, and the truth sitting where it landed, waiting to see what anyone chooses to do with it. But I think about my father often, about a nervous 81-year-old man climbing into a cab because his son had taken his car keys, riding 40 minutes to a stranger's office, sitting across a desk from someone who had no reason to lie to him, and insisting, clause by clause, that the record be set straight. He didn't do it loudly. He didn't confront anyone. He just quietly, deliberately, made sure the truth would still be sitting there, waiting. Whenever someone finally came looking for it, I did come looking. And I found him. Not in a courtroom, not in an argument, but in a single page in a folder. In his own careful words, saying the thing he'd never gotten the chance to say to my face, that he knew exactly who I was, and exactly who had been there all along. A few weeks after the ruling, I drove out to the cemetery on a Sunday morning, the same day of the week I used to call him, out of a habit I haven't quite been able to break even now. I brought the coffee can with me. I don't know why exactly. It felt like something he should have back, in whatever way a headstone can hold a thing. I sat on the grass beside it for a long while, and I told him what had happened. The will, Mr. Halloway, the taxi, the signature that gave him away. I told him I was sorry it had taken so long, and that I understood now why the last few years of our Sunday calls had sometimes carried a strange, careful weight to them. A kind of tension I'd never quite been able to name at the time. I think he was carrying all of it alone for longer than any of us knew, trying to figure out how to make it right without breaking his family apart any further than it already was. I don't know if he managed that in the end. Some family fractures, I've come to accept, don't close just because the paperwork does. But I know my father tried, in the only way left available to him, steady and unhurried, on his own 2 feet, in a stranger's office where no one had any reason to talk him out of the truth. He didn't leave me an argument. He left me evidence, and when I finally needed it, it was still there, waiting exactly where he'd put it, patient as he always was. That, more than the money, is what I carry with me now. Not the $170,000, though I won't pretend it hasn't mattered. It has. In every practical way, a family needs money to matter. What I carry is the knowledge that even at the very end, weakened, watched, running out of time, my father found a way to make sure the truth would outlast whatever was said about him in his absence. He didn't shout it. He didn't fight for it in the moment. He simply made sure it would still be standing, long after he wasn't, for someone patient enough to come and find it. I was that someone. I'm glad I didn't stop looking.